A recent legal development from the Fifth Circuit Court of Appeals has shifted the conversation around suppressors and their place under the Second Amendment. Originally, a three-judge panel on that court issued a decision stating that suppressors, also commonly called silencers, do not qualify as arms under the Constitution. That interpretation meant they weren't entitled to the same protections that cover firearms like handguns, rifles, and shotguns. But now, that decision has been officially withdrawn by the court itself, a major reversal that came shortly after the U.S. Department of Justice under the Trump administration changed its legal position on the matter. Here's what happened. The case in question is United States v. Peterson, which challenges how suppressors are regulated under the National Firearms Act, also known as the NFA. In this case, Mr. Peterson was convicted for possessing an unregistered suppressor, a violation under the NFA. He fought the conviction on constitutional grounds, arguing that the federal government's regulation of suppressors violates his Second Amendment rights. At first, a three-judge panel from the Fifth Circuit sided against him. Their ruling declared that suppressors weren't arms in the legal sense, and therefore didn't enjoy the protections afforded to firearms under the Second Amendment. But that decision didn't sit well with many in the firearms community, and it seems the Department of Justice came to agree. The turning point came when Pam Bondi, representing the Trump-era DOJ, submitted a revised brief to the full bench of the Fifth Circuit. In this updated filing, the government took a firm position. Suppressors are indeed arms, and as such, they are constitutionally protected. The brief emphasized that neither state governments nor the federal government can impose outright bans on them. However, the DOJ still maintained that the current suppressor regulations under the NFA, which include registration requirements, background checks, tax stamps, and long wait times, do not rise to the level of a complete ban and are therefore still compatible with the Second Amendment. This created an interesting legal balance. On one hand, suppressors are now acknowledged by the government as protected arms, but on the other, the current federal framework regulating them remains intact for now. What's important here is that the Fifth Circuit has now mooted the petition for a rehearing. In plain terms, that means the court is setting aside its earlier decision and stepping back from that original interpretation. This is a major move, especially considering the court is known for its influence on Second Amendment jurisprudence. The Peterson case has now become a flashpoint in the broader fight over how far the Second Amendment extends not just to handguns or semi-automatic rifles chambered in popular cartridges like 9mm Luger or 5.56 NATO, but also to NFA items like suppressors. With this new recognition that suppressors qualify as protected arms, we could see further legal challenges that call into question the heavy federal restrictions imposed on their sale and ownership. This change in legal posture, especially from a traditionally regulation-heavy institution like the DOJ, could signal a growing willingness among courts and lawmakers to reevaluate the NFA, as it applies to accessories and devices that have long been stigmatized, despite their widespread and legitimate use in the firearms community. We'll continue tracking what happens next in United States v. Peterson, and how this could ripple out into other cases involving NFA, regulated gear. One thing's for sure, this is a big win for folks who care about protecting not just the right to bear arms, but also the right to own the tools that make shooting safer and more practical. After facing mounting pressure and a significant shift in the legal landscape, the same Fifth Circuit panel that originally ruled in United States v. Peterson has now chosen to officially withdraw its earlier opinion. While the court didn't spell out its exact reasons, it strongly suggests that the three-judge panel intends to revisit the issue, take another look at the arguments, and deliver a fresh decision. My own take on this was recently confirmed when the full en-banc panel of the Fifth Circuit announced that it had decided to dismiss or moot the pending request for a full court rehearing. Since the previous ruling has been taken off the books, there's no longer a need for the larger en-banc panel to weigh in. That means the case will now move forward with the original three-judge panel reconsidering it from scratch. Now, for those who might not be familiar with the background of this case, it began back in the year 2022 with a high-profile raid on Mr. Peterson's residence in the state of Louisiana. That operation involved around 50 agents from a joint task force made up of federal authorities and local law enforcement. Among them were personnel from the Bureau of Alcohol, Tobacco, Firearms, and Explosives, commonly known as the ATF. The warrant was based on alleged violations tied to a small firearms business Peterson was operating from his home. The accusations included possible straw purchases, sloppy or incomplete firearms transaction formed specifically the ATF, Form 4473, and questionable record-keeping practices. There were even claims that certain firearms traced back to his shop had later turned up at crime scenes. But out of that entire raid, the core issue that sparked this legal fight wasn't related to straw purchases or sales records. It was a single item, a so-called solvent trap, that the ATF alleged had been converted into a suppressor without proper registration under the National Firearms Act. That detail became the linchpin for what is now a major constitutional battle. In response to the criminal charge of unlawfully possessing an NFA regulated item, Mr. Peterson filed a motion to dismiss the case, arguing that his right to own that item was protected under the Second Amendment. That motion was denied, prompting him to file an appeal to the Fifth Circuit. The three-judge panel ultimately sided with the ATF and the Biden-era Department of Justice, concluding that the Second Amendment does not extend to include devices like suppressors. The court took a narrow view of what qualifies as arms. It argued that suppressors are not weapons in and of themselves. They aren't capable of inflicting harm or being used in direct self-defense without being attached to an actual firearm. The panel even went so far as to say that suppressors do not meet the historical definition of tools used to cast at or strike at others. Their logic boiled down to this: if it doesn't project force or act as a standalone defensive tool, it doesn't qualify as an arm. They also claim that a suppressor is merely an accessory and not essential for a firearm to function properly. According to them, it's a luxury item, not a necessity for lawful self-defense. But that view runs contrary to what many of us in the shooting community know. A suppressor reduces hearing damage, enhances situational awareness, and makes training safer, especially when used with higher pressure rounds like 7.6, 2x39, or 5.56 NATO. This whole case touches a much bigger issue: how courts define what arms really are under the Constitution. And with the prior ruling now off the table, the panel has a chance to take a more informed and constitutionally grounded approach when they revisit the case. We'll be watching closely to see how this develops, because the outcome could set a powerful precedent for how suppressors and potentially other NFA regulated items are viewed under the Second Amendment moving forward. Following the initial ruling, Mr. Peterson and his legal team submitted a formal request for an en banc rehearing, asking the full Fifth Circuit Court of Appeals to review the decision. At the time, the Department of Justice, still operating under several holdovers from the Biden administration, argued that suppressors were not protected under the Second Amendment. But once the Trump administration reasserted control, with the Second Amendment task force now headed by Pam Bondi, the DOJ reversed its stance in a significant way. In the updated brief, The Trump-era DOJ clearly stated, "It is the position of the United States government that firearm attachments and components, including suppressors, fall under the protections of the Second Amendment. Therefore, any restriction on owning such devices places a burden on the constitutional right to keep and bear arms. A blanket ban on suppressors or similar components would be unconstitutional." The prior argument made by the government was incorrect. That's a dramatic shift. However, they followed that by defending the National Firearms Act's existing regulatory structure, claiming that its registration and tax provisions are constitutional. Their logic was that the burden it imposes is relatively minor and consistent with historical firearm regulations, especially given their argument that suppressors can be readily adapted for criminal purposes. Still, they asserted that the en-banc hearing wasn't necessary, and that the original three-judge panel should be the one to correct its flawed interpretation. That's exactly what seems to be unfolding. We've just received a formal notice from the Fifth Circuit indicating that the previous suppressor ruling has been officially rescinded. The order reads, "In accordance with the court's directive, the opinion issued in this matter has been withdrawn." Based on that, it's clear the same three-judge panel is now expected to re-examine the case with the DOJ's updated position and constitutional interpretation in mind. Adding another layer to this legal drama is the recent movement on the Hearing Protection Act, what some are calling the HPA Light. It was just reintroduced and successfully passed the Senate as part of the so-called Big Beautiful Bill, clearing the parliamentarian review process. But let's be clear, the current version of the HPA doesn't fully remove suppressors from the National Firearms Act. What it does is eliminate the $200 transfer tax, bringing the cost down to $0. However, the Federal Registry, background checks, and transfer requirements all still remain in place. So while it's progress, it's far from a full repeal, and that distinction could play a role in upcoming litigation. Right now, there's a lot in motion. This Fifth Circuit suppressor case is far from over. There's another challenge headed to the Supreme Court, and the legislative fight for a full, robust version of the Hearing Protection Act is still underway in Congress. This is a pivotal time for the future of suppressor ownership and firearm rights in America. As more information comes in, I'll continue to keep you updated. If you want to support the work we're doing here, check out my website over at armscholar.com. There, you'll find a free legal guide for gun owners, curated merchandise, and some solid firearm deals. Thanks again for tuning in. Make sure to drop a like, leave a comment, and hit that subscribe button. And remember, this republic was founded by armed scholars, and it's going to take armed scholars to preserve it. Stay sharp, stay legal, and stay free.